5 seconds to go. Start. Notwithstanding anything contained in the Code of Criminal Procedure 1973 2 of 1974, every offence punishable under this Act shall be cognizable. No person accused of an offence punishable for offences under Section 19 or Section 24 or Section 27A and also for offences involving commercial quantity shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the application for such release, and where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence while on bail. The limitations on granting of bail specified in clause B of subsection 1 are in addition to the limitations under the Code of Criminal Procedure 1973, 2 of 1974 or any other law for the time being in force on granting of bail. A plain reading of the aforesaid provision would indicate that the accused arrested under the NDPS Act 1985 can be ordered to be released on bail only if the court is satisfied that there are reasonable grounds for believing that the accused is not guilty of such offence and that he is not likely to commit any offence while on bail. If the appellant herein was ordered to be released on bail despite the rigors of Section 37 of the NDPS Act 1985, then the same is suggestive that the court concerned might not have found any prima facie case against him. Had this fact been brought to the notice of the detaining authority, then it would have influenced the mind of the detaining authority one way or the other on the question whether or not to make an order of detention. The state never thought to even challenge the bail orders passed by the special court releasing the appellant on bail. In Asha Devi versus Additional Chief Secretary to the Government of Gujarat and another 1979 Criminal Law Journal 203, this court pointed out that if material or vital facts which would influence the minds of the detaining authority one way or the other on the question whether or not to make the detention order are not placed before or are not considered by the detaining authority, it would vitiate its subjective satisfaction, rendering the detention order illegal. In S.K. Nijamuddin Supra, this court observed as under: we should have thought that the fact that a criminal case is pending against the person who is sought to be proceeded against by way of preventive detention is a very material circumstance which ought to be placed before the district magistrate. The circumstance might quite possible have an impact on his decision whether or not to make an order of detention. It is not altogether unlikely that the district magistrate may, in a given case, take the view that Since a criminal case is pending against the person sought to be detained, no order of detention should be made for the present, but the criminal case should be allowed to run its full course, and only if it fails to result in conviction, then preventive detention should be resorted to. Stop.